Guys, this hearing starts calm and instantly turns explosive when one argument threatens to erase the entire case. One decision, one moment, and everything you're about to see could disappear right in front of the judge.
I want to give both sides an opportunity to be heard further on this matter. I know that you had submitted memorandum, but before I make my ruling, I want to see if anybody else has anything else you want to add to it. So.
I do, Your Honor. Again, I didn't set it out in my memorandum, but I do want the court to take into consideration an equal protection argument. If I could point out to the court, of course, under section Tennessee Code Annotated 36-4-121, which deals with the division, distribution, and assignment of marital property. Subsection A specifically states, in all actions for divorce or legal separation, prior to the determination of whether it's appropriate to order support and maintenance of one party or the other, the court having jurisdiction shall, and again, shall, make an equitably divide, distribute, and assign the marital property between the parties without regard for marital fault, in proportion as the court deems just based on the facts and circumstances. But if you go further under that section, under 121, under section 2, it goes on to state that in all actions for legal separation, the court in its discretion may, emphasize may, equitably divide, distribute, and assign the marital property in whole or in part, or reserve the division or the assignment of marital property until a later date. So that's the governing rule as far as division of assets in this case. But again, what you have is under the divorce section and legal separation section, under the Tennessee Constitution as well as the United States Constitutions, each party is entitled to an equal protection. So I think it's an equal protection violation when somebody elects under the divorce statute to seek a legal separation or a divorce, that they are treated differently. In this case in particular, if you will recall, Mr. Walker was the subject of what we would classify as abuse at the hands of his wife. We had a hearing. She testified, even admitted in her pleadings, in her interrogatory responses, that she had taken action, that he had fallen. She left him there. She wished he was dead. She had made threats against his life, and the court found it appropriate at the time that we were here to grant him an absolute divorce. And as I said in the memorandum, she's now seeking to set aside that because, again, in the majority rule that is in the statute or in the case law, that death may abate an action. But again, when you're looking at under Chapter 4 of divorce and annulment and things like that, the court can. It states under section 119, upon a hearing, it doesn't say a final hearing. Upon a hearing in the cause, the court is satisfied that the complainant is entitled to relief. It may be granted either by pronouncing the marriage void from the beginning or by dissolving it forever and freeing each party from the obligation thereof, or by separation for a limited time. So that's under 36-4-119. It doesn't say anything under the statute that you have to do the division of assets at the same time of the award of divorce. It just says if the court finds that the complainant is entitled to the relief, then again, you can grant the relief as far as the divorce is concerned. And it goes on under the previous section, 36-4-114, if a defendant admits the facts charged in the bill or petition and relied upon as grounds for divorce, or the bill is taken for confessed, the court shall, underline shall, nonetheless, before decreeing a divorce, except on the grounds of irreconcilable differences, hear proof of the facts alleged as aforementioned, and either dismiss the bill or petition or grant a divorce as the justice of the case may require. You shall do that. So she admitted in her interrogatories that she had threatened to kill. You heard proof at the temporary hearing. It was taken as confessed, and it says you shall grant the divorce. Nothing in here and nothing in the statute goes forward and says you can't make a division of assets in the future, or you shall make a division of assets prior to the granting of the divorce. And if you can do it in a legal separation and you can reserve it, then you should have the same authority and the jurisdiction to grant it in an absolute divorce.
How do you address the case McMahon versus Butler that the wife relies upon as being clear authority for the fact that this court lacks jurisdiction to continue in the case based on the fact that the husband had died?
Well, Your Honor, I think it is distinguishable in the case. If I could hang on just 1 second. In the McMahon case, if I remember, I had it pulled, Your Honor. The McMahon case, if I recall correctly, there wasn't proof offered as to the basis of the grounds for divorce. And it certainly wasn't within the purview that the individual, that being Mr. Walker, who was granted an absolute divorce, was the victim of domestic violence. And given the fact of his frailty, Your Honor will recall the frailty of himself, that Your Honor granted the divorce as part of an order of protection to keep him safe because of the issues. And again, I think the distinguishing factor is that Your Honor, under the divorce statute, where it says you shall grant a divorce upon hearing proof, I think you did that. I don't think there's anything in the record in McMahon, and I may be mistaken, of where there was a hearing as far as grounds. It
does say that at a hearing on February the 7th, 1983, the husband withdrew his complaint in the case.
The tension spikes as the judge confronts the biggest question of all. Does this case die because the husband passed away? One ruling here could erase months of proceedings or keep the legal battle alive.
Proceeding on the counter-complaint of the wife, the trial judge rendered a decision from the bench granting a divorce to the wife and appointing a special master to take proof regarding the assets of the parties. And of course, then he subsequently, as in this case, he subsequently died. When the wife filed, as here, a motion to dismiss, basically arguing that the case had abated. Well, I just didn't know if there was anything else that I've done some research of my own to determine whether or not I continue to have jurisdiction. I wanted to give both sides an opportunity. Let me hear from Ms. Stevens if she has anything to add to what she's already written. For the record, then, let me make the following finding. Number one, in this situation, the husband, Mr. Donald Howard Walker, filed a complaint for divorce on July the 27th of 2023, alleging, among other things, the fact that the defendant wife was guilty of inappropriate marital conduct and indignities to him, which made a continuation of the marriage impossible and impractical. And also, alternatively, alleging that the parties had experienced irreconcilable differences. In addition to that, an order of protection that had been issued by the General Sessions Court for the Cheatham County on behalf of Mr. Walker and against Elizabeth Diane Walker. That order of protection was, as is normally done, pursuant to statute, transferred from the General Sessions Court to this court based upon the fact that we had a pending divorce action here. So that matter was what the court then dealt with. And the grounds of that order of protection, as alleged by Mr. Walker in his sworn petition, was, one, Diane was mad and has been depressed. Diane told me she was going to kill me and anyone affiliated with me. Two, Diane told me she wanted me dead so that she could have all our money. Three, she took the safe key that has the guns and important papers and hid my medication from me. Diane has family history of mental illness. And then it gives an address. So then there was a notice of appearance filed by Ms. Stevens in August of 2023 and an answer and counter complaint to that divorce. And this is significant for this court's, at least in this court's opinion. There was an answer and counter complaint filed August the 30th of 2023. In that answer, there was a denial of the grounds and so forth, as is usually done. And then there was a counter complaint for an absolute divorce as well. And the counter complaint alleges that the husband was guilty of inappropriate marital conduct. And therefore, both parties in this case sought a divorce. Then Ms. Roberts came in representing the plaintiff and filed her motion for a judgment on the pleadings, and we had a hearing that took place on both the order of protection and the motion, and that hearing took place on January the 22nd of 2024. Actually, I believe that, yeah, those dates I gave earlier were 2023, so this was January of 2024 when the hearing took place before me, and at that time it was a hearing on the extension of an order of protection that had been issued ex parte, a motion for exclusive possession of the marital residence, a motion for judgment of the pleading. At that time, I entered an order which stated that the order of protection would be issued, and I made specific findings which were incorporated into that order, which says, upon the testimony of the defendant, Elizabeth Diane Walker, and the plaintiff, Donald Howard Walker, exhibits presented and review of the pleading, the court finds that the defendant, Elizabeth Diane Walker, presents a credible threat to the plaintiff, Donald Howard Walker, and has made threats threatening the plaintiff's life. Further, from the proof offered that the plaintiff owned the home where the parties resided prior to their marriage, and due to several health issues, he should be awarded exclusive possession. And went on to state that through her testimony, the defendant did not present sufficient evidence to establish a need for spousal support, nor did she establish that the plaintiff had an ability to pay. So therefore, the order of protection was issued against her. And then in a second provision of that order, it is ordered and judged and decreed that based upon the sworn testimony of the respondent, her admissions found in sworn discovery responses, and the finding of the court that the plaintiff's current medical condition necessitates, the court awarded a judgment on the pleadings and grants an absolute divorce to the plaintiff on the grounds of inappropriate marital conduct of the defendant, and hereby restores both parties to all rights and privileges of unmarried person. The issue of the division of assets and other related matters is reserved pending a final hearing. So that is the order that we're dealing with. Subsequent to the entry of that order, Mr. Walker passed away, and that there was a suggestion of death, I think, filed by both parties in the case to substitute the executor of his estate for Mr. Walker. And I believe that was also done by an agreed order that the estate of Donald Howard Walker was substituted as the plaintiff in the matter. So then on October the 16th of 2024, Ms. Walker filed a motion to set aside a final order of divorce. And then on, I believe it was a subsequent time that Mrs. Walker, through her attorney, filed a motion to dismiss the case based on the death of Mr. Walker, and cites the McMahon case as being an authority for that. This court has reviewed all of that information, and the court took the matter under advisement so that I could try to make sure that I was doing the correct ruling in this particular case. And I've looked at a number of cases myself. So I would simply make the following observation. I've considered the case law, the arguments made by the parties, and have carefully considered the holding in the McMahon versus Butler and relied upon by the defendant. In this court's opinion, that case on its face appears to adopt a rule that the death of a party before the adjudication of all issues in the divorce robs the court of jurisdiction to further resolve any issue. However, the McMahon court recognized that there could be certain exceptions to that rule. There are other cases that have recognized exceptions to the McMahon holding and hold that the central issue in the trial is the trial court's intention regarding the entry of the divorce decree to determine whether an order of divorce is effective. Principally, the court relies upon Bradley versus Bradley, a 1990 Court of Appeals unreported decision found at 1990 Westlaw 131404.
The legal turning point where case law breathes life back into a case many assumed was over. Prior rulings are pulled in to prove that intent matters more than timing, completely shifting the direction of the outcome.
In which the wife appealed the dismissal of her purported husband's divorce action where he died after a judgment of divorce was pronounced in open court, but before the entry of the decree. Citing other cases which were somewhat contradictory in their holdings, the Bradley court relied upon the prior case of In the Matter of Connie Sue Littrell, a 1988 unreported decision of the Court of Appeals, to hold that the validity of an order entered after the death of one party depended on the intent of the trial court as to the date of the trial court intended it to be effective. In other words, they relied upon the fact that whatever the trial court intended as to the date of the entry of the order, that would be the effective date. The Bradley court then remanded the case back to the trial court for the entry of a nunc-pro-tunc judgment as to the divorce if he intended it to be effective as of the date of the hearing, and later for a division of property, and such their proceedings, if any, may be necessary. So obviously in the Bradley case, the court found that the husband's death did not prevent the trial court from making a division of property if in fact it was his intent to grant the divorce as of the date of that hearing. And they remanded it for not only the entry of a nunc-pro-tunc if that was the trial court's decision, but also intent rather, but also for further proceedings, including a division of assets. So that Bradley court, which is the same level as the McMahon court, and actually is a more recent case than the McMahon, clearly made it clear, or clearly indicated that the trial court would retain jurisdiction to make a division of property despite the death of the husband in that case. Another case, the Daniel versus Daniel, which is a 1998 Court of Civil Appeals case, which is found at 1998 Westlaw 5500. In that case, the parties had appeared before a trial court and announced that they had negotiated a settlement agreement as to some, but not all of the issues. But they stipulated, and this case is, I think, extremely important and relevant to this court's decision. They stipulated in Daniels that they desired the trial court to grant a divorce that day and restore Mrs. Daniels' maiden name to her in light of the fact that she had been diagnosed with terminal cancer. Mrs. Daniels subsequently died before the remaining issues were resolved. The husband then sought, as here, to dismiss the case, which the trial court denied. The Daniel court framed the issue as follows, and I'm quoting now the language of the Daniels court. The issue submitted for appeal centers on whether the death of a party during the pendency of a divorce action abates the divorce action, or whether the action may, in certain circumstances, survive the death of the party. And that's found on the second page of the Daniels unreported decision. The Daniels court held that the trial court's order was not a final order because it reserved certain issues for later determination, but also found that the evidence was plain that the trial court intended the divorce to be effective on the date of entry of the order, memorializing the announced agreement and stipulation. In reaching its decision, the Daniels court held that the common thread in Tennessee law on this issue is that the intent of the trial court as to whether and when the order of divorce is effective is paramount. And that's found on page 4 of the Daniels decision, and they're relying in that case upon the Bradley versus Bradley decision. Relying on the Bradley decision and the clear intent of the trial court in the Daniels case, the Daniels court remanded the case to the trial court for entry of an order, nunc-pro-tunc, as to the divorce, as to the date the trial court intended the parties to be divorced. In the present case, based upon the evidence at that January 22nd, 2024 hearing, this court intended and expressly found that the plaintiff husband should be awarded an absolute divorce on that date due to the wife's proven conduct and the husband's serious medical condition. Under the authority of Bradley versus Bradley and Daniel versus Daniel cited above, this court finds that the death of Mr. Daniel does not abate this action and that this court continues to have jurisdiction to rule on the remaining issues. Rule 54.02, subsection 1, provides that the court may direct the entry of a final judgment as to one or more but fewer than all of the claims involved in a case upon express determination that there is no just reason for delay. Although the order entered on March the 13th of 2024, reflecting this court's ruling at that hearing on January 22nd of 2024, did not specifically refer to that Rule 54.02 subsection 1. It was this court's express intention, and I state that for the appellate record or anyone else, it was this court's express intention that the entry of that order granting the husband the divorce was to be a final judgment on that issue, and that no just reason existed as to delay that order. So, based upon all of that, it is my opinion that the motion to dismiss this case as having abated is not well taken, that the majority of cases that I've cited clearly make it, more recent cases, make it clear that this court continues to have jurisdiction where this court, by express intention, intended to grant the divorce to one of the parties, and this court finds that that does not dissipate or does not create a situation where the court has no jurisdiction due to the death of Mr. Daniel. In addition, both parties sought a divorce. And so all I did was on that day grant the divorce to the party that I thought had proven the grounds. And I'm convinced that that was the correct decision to do in that particular case. The serious medical condition of Mr. Walker necessitated the entry of the divorce as well. And because of that fact, I felt that there was expedient and necessary to go ahead and grant the divorce and divorce the parties. Based upon this and all of course, I'm aware of all of the language and the statutory language that this court cannot make a division of property in regard fault. So in a sense, my granting the divorce to Mr. Walker did not enhance or even create a detriment to Mrs. Walker's claims for division of property. The division of property would continue nonetheless, despite the fact that Mr. Walker had passed away. So since I could not consider fault, granting a party a divorce would not inhibit her or prevent her from being able to resolve the case or to litigate the issue of property division, which will remain with this court. Anything further, Ms. Roberts will draw the order reflecting this court's decision, and I think that will conclude this matter, at least temporarily.
I'll get that order entered, and then we will proceed. The only question at this point, that the estate has been substituted as a party, so we'll just pick it up and we'll have to go to mediate.
In addition to that, I would simply also point out that the estate had an issue. I think you were delaying some things based upon put that in the following.
But we can proceed with mediation in this matter.
Well, and I'll let you resolve the issues about the estate. So. All right. Ms. Roberts will draw the order. Thank you.
The judge delivers a firm ruling that shuts down the dismissal attempt and keeps jurisdiction alive. Property issues will move forward. The divorce stands, and this case isn't going anywhere despite the death involved. If this breakdown helped you understand what really happened, like the video, subscribe to the channel, and we'll see you in the next video. Do you agree with the judge's decision? Or should the case have ended here?